What are the restrictions for asylum in the United States? What are the factors that will be considered to decide whether this individual could have applied for asylum or not? There are three main restrictions for the asylum, for the eligibility for asylum in the United States, and those three restrictions are either firm resettlement, that means there is a third safe country where you can go, or that you have a permanent residence or citizenship of a safe country where you can actually go instead of remaining in the United States. There is a one-year deadline restriction, which means that you have to apply for asylum within the one-year deadline, and there are exceptions to that. And the third restriction is criminal grounds or national security grounds. So if the asylum applicant has committed certain crimes, which would bar his or her eligibility for the asylum in the United States. Now, going back one by one through those restrictions, I will try to explain, starting with the one-year deadline. The one-year deadline restriction refers to applying for asylum, meaning filing the asylum application within the first year of the presence in the United States. It requires that the asylum applicant must apply for asylum within the one-year period from the time of the last entry into the United States. It's a very strictly enforced restriction, however, it does have its own exceptions. And those exceptions, if we put it under one umbrella, the exceptions can be characterized as extraordinary circumstances, or the exceptional circumstances. And what do those circumstances include? It includes, for example, if there was a change of circumstances in the asylum applicant's either country conditions or the circumstances of the asylum applicant. What it means is, for example, that someone who's been in the United States for more than 1 year and something had happened recently which now created the eligibility for asylum for that individual, then it can be demonstrated that since eligibility that just came up, it wasn't there a year ago or 2 years ago, that's why he or she would be able to apply for asylum, notwithstanding that he or she is applying within after 1 year of the presence in the United States. Then it could be also change in the circumstances in the home country of the applicant. So, for example, if there is a revolution and the applicant has been here in the United States for many years, and then the government of the applicant's home country is overthrown and the circumstances there changed, now there is a reason for the well-founded fear of persecution for the applicant in his or her home country. Then one other exception, which probably comes up most frequently than all others in the context of 1 year deadline, is having a valid non-immigrant status. What does that mean is that if someone has been present in the United States with a valid non-immigrant status, for example, if someone entered the United States with a F1 student visa and they've been here student maintaining their status for many years without applying for asylum, and then by the time they lose their status, or even during the maintenance of that status, during those years while they're still going to school and maintaining their student status, they decide to apply for asylum. This will qualify as an exception to 1 year deadline, and the reason being is that they consider that since this applicant had maintained his or her valid non-immigrant status, they didn't have an urgency, they weren't falling out of status, and they didn't have to apply within the first year of presence, and there was no urgency for them. Nobody was trying to deport them. There was no reason that they would be out of status. So that's why they could have. It kind of tolls the time, the period within which they can apply for asylum. However, if the asylum applicant who had non-immigrant status fell out of status, meaning they dropped out of school, for example, in the context of F1 student, then they must apply within a reasonable period of time. Now, the reasonable period of time is a gray notion. Again, it's still debated in the governments, in the courts in the United States, is what does that reasonable period of time mean? Now, there is a misperception that this reasonable period of time means 1 year from the time that the individual fell out of status. That's wrong. And in fact, the courts in the United States found that it's not within 1 year, the reasonable period of time. It has been found previously that up to probably 6 months, it has been reasonable, but it's looked at case-by-case basis. So the bottom line is that as soon as the non-immigrant is out of status, he or she must apply to preserve their right for asylum. They must apply as soon as possible, immediately. And the next restriction for asylum, as I stated, is a firm resettlement, which basically means that if the applicant has a safe third country to live in, and if the applicant can go to another country, has either a permanent residence or refugee status or citizenship of a third safe country, then they're not eligible for asylum, because for obvious reasons is that asylum is given to someone who has no other way, who has no way out than to remain in the United States. So why then should we grant this individual asylum if he or she can go to the third country? So the asylum is not granted to someone who is willing to remain in the United States because it's a great country, because it has lots of opportunities, but because they have no way out. So if there is a third country where they can go and it would be safe for them, then there is no reason for the United States to grant that protection to that individual. And the third ground is for restriction on asylum eligibility is criminal grounds, and that's for obvious reasons. And if it's national security grounds, if there was terrorist activity committed by the terrorist activities involved in which the applicant was involved, any serious crimes which applicant committed anywhere in the world, then it could serve as a bar to eligibility for asylum. However, it should be noted that many asylum applicants, as part of the persecution, as part of the reason for asylum, have some criminal charges that are brought against them in their home countries. So in that context, the United States government and Department of Homeland Security is aware that not every criminal charge or criminal conviction would serve as bar to eligibility for asylum if it's purely political. And again, the word political is used here in the liberal sense. It doesn't necessarily mean that it has to be political. If the criminal charge or conviction or arrests were based on one of those enumerated reasons, accounts of race, nationality, ethnicity, or membership in a particular social group or political opinion or religion, then it would be considered purely political conviction or charge. Even if the applicant does have some criminal convictions or charges, again, some of them do not rise to the level that it would be barred to the eligibility or restriction for asylum. And just a note, if it does, though, if there is a criminal basis or some other national security basis for asylum, it doesn't necessarily mean that the applicant would be immediately deported back to his home country. There is another convention other than the United Nations Convention regarding refugees. There is a convention against torture. Even if an individual has valid criminal charges or conviction, if there is a valid criminal basis for the home country of the applicant to ask for extradition or to seek or to prosecute this individual who is currently in the United States, physically present, then under Convention Against Torture, this individual can still apply. It wouldn't be for asylum, it would be for relief under Convention Against Torture. It's also known as CAT. If the applicant can demonstrate that he or she would be tortured in their home country. Now, in some of the countries, the way you look at the background of the country, you look at the current country conditions, it's not that hard in some places to demonstrate that he or she would be subject to torture in their home country if they were to go back and if they were to be prosecuted by the government of their home country. So even if there are criminal grounds or national security grounds, the applicant might be eligible for relief under Convention Against Torture, and they would be able to remain in the United States. Of course, it wouldn't lead them, though, to citizenship or permanent residence, but they would have work permit, they would have a chance to remain in the U.S. indefinitely as long as there is still this fear of torture or there is a risk of torture in the United States. But that's a whole different subject in terms of relief under CAT that can be discussed in another episode.